Welcome back to the Toy Report. Just a few days ago, we reported on something really big that happened in Illinois. There were 4 different cases filed by many of our pro-Second Amendment friends against that godforsaken state, each seeking preliminary injunction halting the state of Illinois from enforcing their PICA until there can be a final determination as far as whether or not it is constitutional. The 4 cases were consolidated, and a district judge, Judge Stephen P. McGlynn, granted our friends' requests for preliminary injunction. This judge also acknowledged the importance of pistol braces in the Second Amendment and criticized the ATF's attempt to regulate them, stating that they are overreaching. It's a significant development in our fight against the ATF's tyranny. Well, today we have even bigger news. Supreme Court Justice Amy Coney Barrett has given the city of Naperville in Illinois a stern reminder to provide additional information about their assault weapon and magazine ban. It's almost as if Justice Barrett was saying, "Come on, Naperville, give me some more details or else." It's like one of those damned if you do, damned if you don't type of scenarios. And it's all part of a case in the 7th Circuit that landed as an emergency application in the Supreme Court. So, let's take a moment to talk about this Supreme Court justice who seems to be itching for a brawl over Illinois' absurd assault weapons ban. And why do I say absurd? Well, it's simple. Assault weapon bans are absurd and unconstitutional. It's like trying to ban unicorns or sunshine, if you know what I mean. In his stupid effort to quote-unquote curb gun violence, Governor J.B. Pritzker signed a bill on January 10th that bans the sale of any firearm that resembles military-style weapons and all high-capacity magazines in one of the most anti-Second Amendment states in America today, Illinois. The law even goes so far as to require owners of such weapons to register them with the Illinois State Police, because apparently you can't trust someone who owns a weapon capable of, quote, mass destruction. Pritzker signed this bill 6 months after that horrific shooting at the Highland Park 4th of July parade, where 7 innocent people were killed and 48 more were injured by a deranged man wielding an AR-15 style rifle. In case you forget, during an Independence Day parade in Highland Park, Illinois on July 4th, 2022, a mass shooting took place resulting in the deaths of 7 individuals and injuries to 48 others from bullets and shrapnel. The mentally challenged shooter, identified as 21-year-old Robert Eugene Crimo III, gained access to an elevated position using an unsecured ladder attached to a building. He used a Smith & Wesson M&P 15 semi-automatic rifle equipped with 3 30-round magazines and fired a total of 83 shots, hitting both spectators and participants in the parade. Law enforcement officers from multiple agencies responded to the shooting, prompting the shooter to flee the scene and later being apprehended over 8 hours later in Lake Forest, Illinois. Let me quickly share the filed document with you, and for all you Second Amendment nerds like myself, I'll make sure that the link will be available in the description. Here is the emergency application for an injunction pending appellate review. The question at hand is straightforward. Can the government prohibit the sale, purchase, and possession of specific semi-automatic firearms and magazines, which tens of millions of law-abiding Americans use for legitimate purposes without any historical precedent as required by previous cases such as D.C. v. Heller and New York State Rifle and Pistol Association Inc. v. Bruin? For now, let's fast forward to the good stuff. The conclusion. The plaintiffs have really done their homework and ticked all the boxes needed to prove they deserve injunctive relief, while the appellate review is underway. They were essentially asking Justice Amy Coney Barrett to either grant this application or pass it on to the full court. The plaintiffs went all in and requested the court to restrain the enforcement of these laws until a full appellate review of the district court's order denying their motion for an injunction that would have otherwise done the job. Fingers crossed that this works out in their favor. This news is hot off the press, folks. Just days after a preliminary injunction was issued in Illinois, we are yet seeing again another big glimmer of hope. If you live in Illinois and are itching to get your hands on some banned items, Brownells is now shipping there. Huzzah! And with Justice Amy Coney Barrett jumping into action, this could be the start of something superb. So, the plaintiffs in this case, the National Association for Gun Rights, or NAGR, and an individual by the name of Robert C. Bevis, who owns a gun store in Naperville, Illinois, challenged the law in the U.S. District Court in Chicago, arguing that his law weapons and supply business suffered because of the ban and might end up closing if he can't sell his merchandise. His lawsuit was just one of several seeking to overturn the ban. Bevis and his lawyers are citing Supreme Court rulings that state that a weapon must be deemed dangerous and unusual to be banned. Their argument is that since assault-style rifles are frequently owned by law-abiding folks for lawful purposes, they cannot be considered unusual and therefore shouldn't be banned. However, their hopes were dashed. the woke trial court wasn't too keen on granting an injunction to stop the city of Naperville's so-called assault weapons ban. U.S. District Judge Virginia Kendall ruled against them, finding the ban to be constitutionally sound. In her opinion, Kendall noted that these types of rifles are particularly lethal, and thus, regulating them aligns with the historical and traditional approach to weapon control. Not once to give up without a fight, the plaintiffs quickly appealed to the 7th Circuit. But alas, it was all for naught. The 7th Circuit gave them the old sorry not sorry routine and upheld the trial court's decision. Tough luck, huh? Or is it? The plaintiffs then sent an appeal directly to Supreme Court Justice Amy Coney Barrett, who was in charge of appeals from the 7th Circuit. What the plaintiffs did afterward was a power move that is highly commendable because it is rarely seen in the legal world. They went straight to the big leagues and appealed directly to the United States Supreme Court. Yep, you read that right, but why the bold move, you might ask? Well, they did it because each justice is responsible for overseeing a particular circuit of the United States Court of Appeals, and in this case, it's none other than Justice Amy Coney Barrett, a stalwart ally and one of the most powerful defenders of the Second Amendment. It's a calculated move to bring in the big guns. They wasted no time in asking for an injunction. Our friends, the plaintiffs in this case versus Naperville, are not messing around. Now, this move by the plaintiffs is not just impressive, it's downright genius. See, typically, when you appeal to the United States Supreme Court, they like to really, as in really, take their sweet time and let the case marinate indefinitely, and before you know it, 10 years had already passed, and only after then will they decide to take action. Okay, I'm exaggerating. Maybe not 10 years, but you get the point. Not in this case, friends. The beautiful yet strong non-woke female protagonist of this story, Justice Barrett, is not messing around. She straight up told the city of Naperville, "Hold up, I want to hear from you first. Give me one good reason why I shouldn't issue an injunction, and you better do it by May 8th. That's 1 week from now." This is like the legal equivalent of a mic drop. So, let's break this big news down to small, easily digestible bits. If Justice Barrett ends up issuing an injunction on this assault weapons ban, it won't just affect Illinois. It'll send a strong message to all states that currently have similar laws in place. Basically, it'll be a crystal clear writing on the wall for anti-gunners saying that their days of proposing and signing unconstitutional anti-Second Amendment bills into laws are numbered. It is something we already know, but it feels so good to have it officially recognized. And that's not all. This could also be a sign that the Supreme Court is gearing up to take on one or more cases related to this issue and settle it once and for all. Remember, Illinois' assault weapons ban didn't exactly win over the hearts and minds of law enforcement. Literally every single sheriff's department in the state was openly critical of it and believed it to be unconstitutional. So, if the Supreme Court takes on this issue, it'll be a chance for them to make things right and give law-abiding citizens the right to defend themselves with the weapons they choose. It's like the Wild West, but with suits and ties. It's safe to say that even though this Naperville anti-Second Amendment law went from 0 to 100 in a jiffy, with the way things are going, it will go back to 0 just as fast. It's like the legal equivalent of a drive-by shooting. It came out of nowhere and caused chaos, but now we're hoping justice will be served and it'll be put to rest. Now, if you've got more burning questions about what's going on in Illinois, other assault weapons bans, or anything related to your Second Amendment rights, fear not. You know how to reach us here at the Two-Way Report. If you don't, no worries. Posting a comment down below literally takes a second. And that's all I have for you today. If you have family and friends living in Illinois, please share this video with them so they're aware of what's going on. Like, share, subscribe, and click on that little notification bell too so you don't miss out on the latest pro-Second Amendment news. Thanks for watching and you have a good one.